In the appeal of Lescene Edwards against the Queen.
Good morning. Yes.
Good morning. I represent the appellant together with Mr Graham Hall, and Mr Poole QC represents the respondent. My Lords, there are a number of documents which are within a key core document bundle, which I can see that your Lordships have. In addition, I'll be referring to some of the authorities. And my Lords, my Lady, if I may take the appeal in this way, firstly, I will move to address on the application for permission to admit fresh evidence, and that fresh evidence comprises the evidence of the joint report of Angela Shaw, who's the gunshot residue expert, together with Mr Mastaglio, who's a ballistics expert, and also the report of Gillian Leake, who is the blood spatter expert, if I can call her that. I'll then move on to addressing the constitutional appeal. And my Lady, my Lords, I'll then move on to addressing the 6 grounds of appeal, which are set out within our case at paragraph 46.
I suspect you can address us on the constitutional appeal fairly shortly, because the Crown concedes that a declaration can be made. So as far as the forensic debate is concerned, you're pushing at an open door as far as the Crown is concerned.
Yes.
You may also take it that the board has read all the documents contained in the key documents bundle and the reports for which you're making the submission in relation to the admission of new evidence.
My Lord, I'm very grateful. Yes, in relation to the constitutional appeal, there's an acceptance of breach of Section 16 of the Constitution. So the only issue is relief between ourselves and the respondent. Moving firstly to the fresh evidence and summarising the position of the appellant, the prosecution case relied on circumstantial evidence. However, all of that circumstantial evidence was founded on error and also on unfairness. And the following headings are relied upon. The investigation did not follow basic competent duties, specifically, but not exhaustively, preserving the scene of Ms Harris-Vasquez's death. The scene was cleaned before the crime scene investigator arrived. That investigator, in fact, only arrived on the 6th of September, the day after Ms Harris-Vasquez's death. And also, it was accepted in evidence that cleaning up the crime scene would not be the thing to do, and that's referred to at page 1523 of this, which is of the summing up. The firearm and holster were not sent for fingerprint and/or DNA testing. There were no swabs taken from the bathroom. The exhibits were not stored or sealed properly, and then ultimately all were destroyed some 4 years before the case came to trial. And overall, in terms of investigation, the learned judge at trial, in her summing up, described the deceased's niece, Miss Kellyanne Johnson, as being a better detective than the detectives who were there, and that can be found at page 1489. It was, to remind my lady, my lords, it was at the direction of Senior Superintendent Stewart that she mopped up her own aunt's blood with bleach and water. The second heading is handwriting, and it's submitted that the prosecution handwriting evidence, that of Mr Major, was based on a flawed methodology. Mr Edwards had been directed to follow or write from the, I'll refer to it as a suicide note, the note that was located in the bedroom at the property. And it was agreed between experts, and I'll come on to it, that the method of obtaining a specimen should have been by dictation rather than copying from the disputed handwriting. So the basic process was flawed. Next heading is interview. Mr Edwards' full interview was read to the jury, and the jury had a copy of it to take with them. It included police speculation of theories, which was not evidence, but was highly prejudicial, including suggestions to him that he'd been in a fight with Miss Harris-Vasquez's husband, and that he had issued threats towards the husband and towards Miss Harris-Vasquez, none of which was underpinned by any evidence whatsoever. Then finally, there was a delay of 10 years until trial. And the prejudice there is that, in particular, witnesses could no longer be located, and I've referred to the exhibits being destroyed, but the witness of particular importance was Sergeant Brown, who it was discovered at the trial was no longer available.
That was because of the issue about whether she found the note or whether the appellant pointed it out to her.
Absolutely,
so
my lord.
You weren't able to contradict the evidence to the effect that she told her colleague that that the accused had pointed this evidence out.
Yes, absolutely, my lord.
Which you understandably say is an important.
Yes,
evidence.
Yes, particularly as now is emphasised in the respondent's written case, that the note was the central plank of its case, is how the respondent puts its case, rather than the forensic evidence being a central plank. It relies on the note itself, and therefore all evidence around that note needs to be considered with real care. In relation to Sergeant Brown, there was some evidence as to what she'd written in her statement, in that it obviously was set out in her statement that she had not pointed out the note on the instruction of Mr Edwards. But we submit, as such an important topic, it was very limited.
But the statement was not put in evidence.
No, it wasn't. Yeah.
Was it not? Her statement?
No.
It was put to Detective Inspector Phipps, but why was it not introduced into evidence?
Yes, that's right. It was put in cross-examination to the inspector and showed to him.
Yes, but
and read out.
It was a cross-examination document rather than.
Yes.
Why my lady's question, why wasn't it put in evidence then? No, it just wasn't.
I'm limited as to why not. What I would say in relation to that, my lord, is obviously the context is important in the context of the trial. And my lady and my lords probably see from the record that objection tends to be made in Jamaica as issues arise, rather than that there are procedural applications on matters of law to exclude or include. And therefore, this document appeared to follow that sort of lack of procedural rigour, if I may put it that way, which is within the context of how trials are run in Jamaica.
But do you accept that if it's put to the police witness, if he doesn't accept it, which he didn't, then it's not evidence in the case?
Yes, yes. The evidence is obviously coming from Mr Phipps, yes.
But Mr Phipps's statement was put to him, I think, and there was nothing in his statement about him having learnt about the notebook from Mr Edwards. So it was something he came up with for the first time, as far as we know, 10 years after the event.
That's right, my lord, yes. And he stuck to that evidence that is what the officer had said. So he didn't resile, even when shown his own statement and Sergeant Brown's statement. He didn't resile from that part of the evidence. And then it was referred to in summing up. And the impact on the jury cannot be obviously fully understood, but it was highly prejudicial on such an important matter.
Yes.
In relation to the Court of Appeal's approach under that heading, we'll come on to our submissions as to why respectfully we say the Court of Appeal fell into error in dismissing the grounds of appeal submitted to it. We draw attention to the Court of Appeal's finding that, and this is, perhaps if we just take you to it, it's in the core bundle at page 1928, behind tab 7. Sorry, behind tab 9. It's at paragraph 53. Looking at the strength of the prosecution case, bearing in mind that the issues drawn between the parties at the trial, it cannot be said that the prosecution's case was such that a conviction was inevitable. And that in our submission is relevant when we also come on to considering the proviso and also the constitutional breach part of the appeal. However, in dismissing the appeal, the Court of Appeal in our submission fell into error in its reliance in particular on submissions it took as seeking to displace the verdict of the jury. And my lords, my lady, it's at paragraph 1916. Page 1916. This is where, to put it into context, paragraph 24, this is where the court is considering the case of Lau and considering whether the verdict of the jury was one which was palpably wrong. However, at page 1914, the submission from the appellant was in fact in relation to how the trial judges summed up the case, rather than in our submission, a Lau situation where there's no complaint about the summing up of the case or directions given to the jury. However, it is said that the evidence is such that the jury have got it palpably wrong. And this is not the case here in our submission. This is a case where there are numerous areas of inclusion of evidence or exclusion of evidence or absence of evidence, such as make the conviction unsafe, rather than a situation where the jury had all the relevant evidence or was directed and the evidence was summed up properly, or the prejudicial evidence was excluded and then reached a verdict of guilty as it did. And we'll return to the case of Lau, but I refer to it at this point because the respondent relies upon it. And our submission is the Court of Appeal was slightly wrong-footed there in its reliance, and it conflates the two submissions from the appellant. which is a complaint about the summing up, which morphs into considering the actual verdict of the jury and whether the evidence was such as so different to what a perverseness in effect is what it then relied upon and relied upon Lau. And that was the respondent's position in the Court of Appeal, which might have led it into error. The delay of 10 years, our submission is that this delay could only lead to the conclusion that the trial was not fair. Two aspects to that: either that it was not fair to try the appellant at all, or that when the trial was completed, it demonstrated that that trial had been unfair. And in summary, the submission is that individually or cumulatively, the delay, the inadequate investigation, the flawed methods employed to obtain the forensic and handwriting evidence, the loss of evidence, and the fresh evidence compellingly demonstrate that Mr. Edwards' conviction is based on a miscarriage of justice and that his conviction must be quashed.
A lot of the points you make under the heading of the trial being unfair because it took 10 years are actually points that have nothing to do with the delay. I mean, your complaints about the investigation would be just as good or bad if the trial had taken place 2 years after the event. In fact, there's hardly anything in your case, really, which depends on the delay, as far as I can see. I mean, all you've really come up with was the fact that Sergeant Brown wasn't there as a witness, but, I mean, that sort of thing can happen anyway.
I suppose it might be argued that the destruction of the evidence 4 years before the trial was indicative of the consequences of delay, because it was 6 years after the event. But yes, I mean, you have a number of significant points to make to us which don't depend on delay.
Yes, I accept the steer that is perhaps coming in my direction. In relation to delay, we do rely upon Brown, as has been identified, the absence of Brown, but we submit that there is real significance, even though it's one witness. This is an incredibly important witness.
But do we know when she left Jamaica? She may have left Jamaica 6 months after the trial. And
the only information it appears given to those representing Mr. Edwards at trial was she'd emigrated and could not be located.
Presumably she only turned out to be important because whoever he was, I've forgotten his name now. Mr. Phipps.
He denied.
Gave some evidence which wasn't in his statement. Yeah. Presumably it came as a surprise to the defence, I would imagine.
Yes, although it is circular, of course, in that the Crown has the obligation and the duty to get its witnesses there, and the sergeant was expected to be there. Certainly there were no red flags, but when a witness is not there, it is not unheard of that another witness might take comfort from somebody not being able to contradict them, not being there, which is why there's such an onerous duty on the Crown to get its witnesses, and that obligation should never fall upon the defence to do so, or to question, in fact, in advance, are your witnesses here? The presumption is that the witnesses will be there, and this may well have been what happened in this case, that Mr. Phipps took some comfort from knowing that Sergeant Brown was not going to be giving evidence to contradict him.
Given that the Crown's position now is that the handwriting evidence was central, then I can see your point that the inability to question Sergeant Brown on whether or not the accused pointed out the note is of some significance. Yes,
I'm grateful. It's become of significance, but perhaps hence that's why we are here. In that ground became strengthened as the evidence progressed. In relation to the fresh evidence, first of all, the application to introduce the fresh evidence just for your page note, if you wish, is at electronic bundle 2048, and it's within the appellant's case at page 2276. Which is behind tab 4 in the core bundle. If I may take my lady, my lords, to the evidence that is sought to be admitted. Ms. Gillian Leake's evidence is at page 2069 in the electronic bundle. And for the joint report by Mr. Mastaglio and Ms. Shaw starts at page 2096. There's two reports of Ms. Leake because the photographs she received were clearer photographs which made up her second report, and that only strengthened her conclusions. If I may deal with Ms. Leake first, in summary, her conclusions, the purpose of her examination is set out at page 2072, and then she carries out her analysis looking at the blood spatter throughout page 2079 on to 2082, and at page 2082 where she's asked the question, can suicide be ruled out? She answers no. Given the various points discussed earlier, I considered the findings collectively to be more supportive of an act of suicide. And then at little 3, she sets out, I consider the findings to be more readily explained if this were to be a result of an act of suicide. And then in her further report, the key paragraph is at page 2094 under discussion and conclusion, where she says, in my opinion, the blood patterns indicate Ms. Harris-Vasquez was initially seated on the floor in the bathroom with her back against the left side of the door and jamb. The door was closed at this point. The patterns, together with the post-mortem findings, indicate the shot was to the right-hand side of her head. The area of space available for someone else to be present here and delivering the shot would be minimal. It's a very tight space. And then at page 2095, this is where she looks at the prosecution hypothesis and looks at the defence hypothesis, namely whether Mr. Edwards shot Ms. Harris-Vasquez or whether she shot herself. And she sets out, in my opinion, these additional findings add further to support to my original conclusions in that they can collectively be far more readily explained if the defence hypothesis were to be true rather than the prosecution hypothesis, and in keeping with what I may expect to find if that shot was self-inflicted. To summarise the firearms residue fresh evidence, which continues, the purpose is set out at page 2000.
So before you leave the
Yes.
first evidence, while I'm thinking of it, is there any evidence as to whether Mr. Edwards is right-handed or left-handed? I'm just looking at the picture on 2091.
Yes. Can I? We did.
You're coming to that in more detail, are you? But
yes.
But there she is, with the gun having been shot in her right temple, which is pretty near the wall. So, if he was right-handed, it would have been pretty difficult for him to get his hand round and in there.
If we can just get back to you on that, my lord, it is a point we did consider, but over a couple of years ago now, I think. Right. So we can just get back to you. Thank you. The other aspect, perhaps before I leave Miss Leake, to draw to the attention of my lords, is also her finding about the arterial blood, which she refers to at page 2081. And this is of significance. It's just underneath the photographs, which are photographs where she's demonstrating. I think sadly they use a pig for those photographs, but the lines underneath is where she sets out there's a high expectation of finding projected blood spatter type patterns on anyone that may have been present and stepped over the body of Miss Harris-Vasquez, if Miss Harris-Vasquez was still projecting arterial type blood distribution patterns in the way which partially blocking the doorway. Again, that would have been significant in our submission for the jury to have considered the spurting of blood from her and her positioning by the door, in that another person in the bathroom in exiting would likely, highly likely, according to Miss Leake, have been spattered. So this goes beyond spattering from the act of the shooting itself, but also adds another aspect of forensic material which places further doubt on the conviction in that somebody in that bathroom exiting may well have got caught with arterial blood as well. The gunshot residue, if I may just move to that quickly, the purpose set out 2100, page 2100, and the methodology is considered at 2102. And we place some reliance on the advancement of methodology, in that Ms Shaw considers that the method of using hydrochloric acid, which was used to swab the suspect's hands, is a method that had not been used for several decades in most jurisdictions due to a lack of specificity of the colour reactions for trace elements, inadequate sensitivity and interference of the colour reactions among the three elements themselves. And this, in our submission, is important evidence concerning the reliance that the prosecution placed upon lack of GSR on the hands of Miss Harris-Vasquez. From the report, my lords, my lady, you will have noted that the system of using hydrochloric acid changed in Jamaica in 2016.
Could you just give me the page reference, sorry, to that?
Yes, so point. The hydrochloric acid 2102.
Yes, thank you.
Was the on that page. The change 2103, where she says an article in the press showed that they acquired an SEM in November 2016. Ms Shaw further sets out at page 2105 that...
Am I right that the GSR evidence that they produced, test the word, produced a complete nil return?
Yes, complete nil return.
So there was a total failure to find any gunshot residue on anything?
Yes, yes.
Including on Mr Edwards?
Yeah.
Including on Mr Edwards, which...
And yet the absence was said to be tremendously significant.
Yes, and yet in the summing up in particular, there was repeated reference to the lack of GSR on Miss
So whatever the Crown's position is now, it appears from the summing up that at the time of the trial, the Crown was founding on the lack of GSR on the deceased's hands.
Yes.
Because, as you say, there are 3 or 4 references to that
Yes.
as a plank in the Crown's case.
Yes, our submission is certainly at that time it was a central plank in,
Yes.
in the Crown's case.
Yes.
Now, Ms Shaw, page 2105, sets out that, in effect, that it's not safe to rely on there being a lack of GSR on Miss Harris-Vasquez. And she, towards the bottom of that, her report at 2105, she queries the efficacy of the swabbing because she, 3 lines from the bottom, says the absence of GSR on the nightdress supports my earlier observations that the method of analysis used in the instant case suffers serious specificity and sensitivity issues, and the results cannot be relied upon. This, therefore, also casts doubts on the reliability of the results from all the tests, all the items tested for GSR in the instant case if the same method was utilised. Her reasoning for that is, irrespective of who had fired the gun, there would have been GSR on the nightdress.
And is that regardless of how close the gun was to the deceased's head? Because I thought somewhere it said that if the gun was right up against the deceased's head, the gunshot residue would go into the wound rather?
Yes, she's looking at this case with the gun right against the head of the deceased.
Yes.
And her opinion is that there still would have been GSR.
Yes, there was evidence, was there not? This was a revolver, and therefore there was the revolving, I can't remember what it's called, with the bullets in it, and there was a gap.
Yeah.
And therefore
Chamber.
some GSR would come out,
Yes.
come out there, and we know that the appellant picked up the gun and dropped it back on the deceased's dress.
Yes.
And I think the evidence was that one would expect there to be GSR from a newly fired gun on the dress.
Yes, absolutely, my lord. I'm very grateful.
So the absence of the dress is a potentially prejudicial factor from the defence's point of view.
Yes, it throws into question the testing, all of the testing on the GSR. She also, at page, she also disagrees with the evidence of Superintendent Hibbert that there would necessarily, if I'll just come back to that, forgive me, but if I can just move to her conclusions. On the crime scene itself, 2107, this is obviously very basic of how a crime scene is secured, and there's a note of who comes in the crime scene and who comes out. So that's standard procedure that she refers to, which was not done here. She, at page 2108, considers how the warhead of the bullet was recovered, and my lords, my lady may recall that because of the type of revolver, the shell is within the chamber. So when the chamber's open, there's 6. It's occupied by 6 warheads, and 1 had just the casing, which is the one that had been fired. And so the warhead here was in the door, but that was not analysed as it should have been in a competent trajectory reconstruction analysis. And so although the appellant in submissions was able to submit to the jury that the trajectory was consistent with the deceased sitting down against the door, it was limited. The submissions were very limited without the proper measurement of the scene itself as to the exact height of the bullet, and the horizontal distance was not measured, and that's set out at page 2109. We had the 2 foot 8 inches above the floor, but then there was no horizontal distance measurement, which would help with the trajectory of the bullet and the positioning.
Are we to conclude from the fact that the bullet was in the door that whoever fired the gun, the door was closed at the time?
Yes. Yes.
So it isn't a case, or it can't be a case of the accused standing outside the bathroom, leaning in and putting his hand round to the other side of her head, firing the trigger, because the door had to be closed, because the bullet went through her head straight into the door.
Yes, absolutely.
We know from the trajectory through her head that it went upwards as well, don't
Yes.
we? And so we do have a fair idea what the trajectory was.
We do. However, in relation to the evidence before the jury as to what that actually meant, that was not able to be developed because there was no proper consideration.
But the bullet was loose within the 2 wooden halves of the door. I guess it wasn't like lodged in the door.
Yes.
Dropped to the, because I think there was some evidence of the door rattling when it.
Yes, but when the niece, Kellyanne Johnson, moved the door, so it was loose. However, there was a lack of measurement.
But we know at least that, as my lord says,
the door was closed.
The door was closed, and she wasn't shot through the door.
Yes, she was shot from inside. In terms of delay, perhaps just to add on to this, the Kellyanne Johnson was asked whether there was any blood on the jamb of the door, and she could not remember because of the passage of time, and that in itself would have been significant evidence as to how Miss Harris-Vasquez was positioned, and in our submission, the impossibility, therefore, of her remaining in that position if there was somebody else in the bathroom with her, and opening the door without disturbing her, so that she remained propped up and then fell out when Mr Edwards subsequently opened the door, and that the blood on the door jamb, if it had been observed or remembered by Miss Kellyanne Johnson, would have assisted the appellant in submissions to the jury and to the learned judge, but she could not remember whether there was blood there or not.
Is that a point that's made in Miss Leake's report, or are you just making that?
I think that was one of our submissions rather than from her report on the delay, so not from her report. She, page 2110, deals with the aspect of the gun, the night dress in the morgue, and considers that would not have had such a detrimental effect on recovery of GSR, and that was a point that was raised before the jury. She does not consider it would have had a detrimental effect. But in conclusion, at page 2112, this is now the ballistics evidence of Mr Magalio. The wound ballistics position of the body, location of the gun and height of the bullet hole in the door can all be explained by suicide. With the deceased, it should be seated adjacent to the hole in the door, seated adjacent to the door when the shot was discharged. The deceased could not have been standing upright when the shot in that case. It would not be possible to line the upward wound path through the head to the lower level bullet strike to the door. Whilst it's not possible to exclude homicide, I've seen no firearms evidence of third-party involvement. And the submission is that without this evidence from ballistics and forensic experts, the jury are left simply with the photographs, and they obviously were limited what photographs they were shown for reasons of prejudice. and they're left with a series of propositions being put in submission form about why the crime scene in particular was not examined more carefully, why it was cleaned up and so on. But there was no forensic evidence to put before the jury that there was no firearms evidence of a third-party involvement, and that the wound ballistics demonstrated the position of the body to be as it was, that she was sat down in that position. And once that evidence, if that evidence had been given, the follow-on thought process would have been, how could Mr Edwards have been in there and exited with the deceased remaining propped up against the corner of the door in that way? And then there would have been undoubtedly further consideration of aspects of whether the body had fallen and then been re-propped up. There was no evidence of blood smearing, nothing to support that. But without this evidence, the jury was left with a series of propositions, whereas the only forensic evidence which was put to them was from the Crown that there's no GSR, there is no gunshot residue, and therefore inference being she did not shoot herself. So the negative.
And there was no, if she had shot herself sitting down, she would have remained sitting propped up. The force of the bullet wouldn't have caused her to fall sideways. Is that right?
That's the evidence from the ballistics and the evidence from Miss Leake that she would have remained seated, propped, but then the movement of the door caused her to fall. And
when Mr Edwards opened the door from the outside?
When he opened it from the outside. And so if the movement of the door disturbed her position, obviously that would have been disturbed if somebody was exiting the bathroom in the same way as when they were opening the door from the other side. There was some support from the photographs of a smear on the door, which was referred to the jury, and that there was, I can take you to the photograph, but it was a smear which was said to be consistent with her head brushing against the bathroom door as it was opened. And that's referred to in Miss Leake's report as well. So, again, the forensic evidence pointed to her remaining undisturbed until the door's open from the outside, and then she falls, and then her head brushes against the door. In summary, whilst counsel, Ms Nita Robertson, was able to put a question mark over the case and the forensics, without the expert evidence that they were relying on, they were question marks and propositions with no evidential foundation. And as to the court's powers to receive fresh evidence, the respondent objects to this fresh evidence being received, and its objection was set out just for reference at page 2133, where the respondent also sets out that section 28 of the Judicature Appellate Jurisdiction Act gives the Court of Appeal power in criminal appeals to receive fresh evidence if it's necessary or expedient in the interest of justice. And we can also take you to the case of Lundy, which is in the authorities bundle at page 2633.
So the respondent's, the page of the respondent's case to which you referred, I'm afraid,
is 2133.
2133. No.
I don't think that's right. No, yes, 2133, this is when they objected to the fresh evidence, so that is in your electronic bundle rather than in the core bundle.
Thank you.
It's a document, it's undated actually. It's headed the respondent's submissions objecting to leave to appeal. And 2133 is the respondent's objections to the fresh evidence. Paragraph 23 and 24. And the issue here is not whether they are, the witnesses are capable of belief, but the respondent's position remains quite similar to as set out in its initial objection, that there's no reasonable explanation as to why they could not have been obtained until July/September 2019 after the conclusion of the trial. And also the respondent's position is that the GSR evidence doesn't particularly take matters much further, even if it had been available for the jury. The case of Lundy, in the authorities bundle at 2,633, if my lady, my lords have that authority. The head note sets out an outline of the case where the applicant was tried and convicted in 2002 of the murders of his wife and daughter, whose bodies had been found in their home in 2000. And the prosecution case, I'm looking about halfway down that head note, it depended largely on 3 strands of scientific evidence. And those strands were analysis of the stomach contents of the deceased showed that they died around 7 p.m. That there was biological tissue on the applicant's shirt, which identified as being the wife's central nervous system tissue, which the defence conceded, and also the home computer evidence as to whether that home computer had been manipulated so that the time was set to later than actually was the real time. And he was convicted and sentenced to life imprisonment. And then in 2012, he applied for leave to appeal to the Privy Council with explanations of delay, including funding problems, on the basis of submitting fresh scientific evidence from several leading international experts. And the application for leave was granted, and the judgment is Lord Kerr, and which starts at page 2637, and the conflicting views of the various experts are set out. And then at page 2665, Lord Kerr goes on to the principles governing the admission of new evidence and looks at the Court of Appeal in New Zealand. And then over the page, at page 2666, at paragraph 120, the board considers that the proper basis on which admission of fresh evidence should be decided is by the application of a sequential series of tests. If the evidence is not credible, it should not be admitted. That's not the position here. If it's credible, the question then arises whether it's fresh, in the sense that it is evidence which could not have been obtained for the trial with reasonable diligence. If the evidence is both credible and fresh, it should generally be admitted, unless the court is satisfied at that stage that if admitted, it would have no effect on the safety of the conviction. If the evidence is credible but not fresh, the court should assess its strength and its potential impact on the safety of the conviction. If it considers there's a risk of a miscarriage of justice, if the evidence is excluded, it should be admitted, notwithstanding that the evidence is not fresh. And also at paragraph 121, Lord Kerr emphasises the requirement that evidence be fresh can be of less critical importance in cases involving scientific evidence. Our submission, this case is predominantly a scientific evidence case. As to whether it's fresh evidence and why it could not have been obtained for the trial with reasonable diligence, the appellant relies upon the statement of counsel, Miss Nita Robertson, and that is set out at page 2145 of the electronic bundle. It's the annex to the application to admit the fresh evidence, so it comes at the back of the experts' reports. And she sets out that there were a combination of factors at paragraph 3, which included there was and there still is not any independent ballistics, blood spatter or GSR analyst in Jamaica. And so persons would have to be secured from overseas, and there were limited resources. Those resources were put into the handwriting expert who was brought over from the United States. And then there was a strategic decision to cross-examine the forensic experts, and undoubtedly with a consideration that that might be sufficient when a submission was made at half-time at the close of the prosecution case, and that proved not to be correct. But in our submission, what's key in whether, with due diligence, counsel could have obtained this expert evidence, our submission is they could not have done, because there was no resources to do so.
What's the position in terms of legal aid in Jamaica? Referring here to the limited resources available from the client.
Yes.
Yes, that he's having to pay for it himself. Is that what
yes.
meant there?
Yes, the legal aid is practically non-existent. I can say that from some experience of working there. But this client was funding privately and could not afford to fund other experts. In relation to legal aid itself, I should say, is very basic, and it wouldn't normally extend to experts. The experts in this case all have given their reports on a pro bono basis after the convictions. So our submission is that with due diligence was applied, but resources were limited, and therefore it is fresh. If my lady, my lords are against us on that, we submit that the importance of the evidence should be considered and the potential impact that it would have, that he has on this case. And the submission by the respondent, and this is in the call bundle, the respondent's written case at page 2305. So it's behind tab 6. The paragraph 7, the respondents it resists because there's no reasonable explanation. We submit there is, and no injustice will be caused by refusing, as there's no basis for saying it could sensibly have made any difference to the jury's verdict. Our submission, that can be tested very easily by considering out loud, as we're doing in our submissions, the evidence from Gillian Leake, which was, in conclusion, I consider the findings to be more readily explained if this was to be as a result of an act of suicide, and that was what it took you to at page 2082. And at page 2095, in my opinion, these additional findings add further support to my original conclusions of suicide, far more readily explained by shooting herself. And that tests in our submission, even by going to the conclusions alone, that tests the illogicality of the assertion from the respondent that it could not sensibly have made any difference to the jury's verdict.
But it was, the case for the prosecution was that this had been got up to look like a suicide by someone who was himself a crime scene investigator. But you say even so, this evidence might have pushed the jury to have a doubt whether that was what had happened here.
Yes, my lady, the prosecution case was certainly that it was staged to look like a suicide, but the staging was relying on the suicide note, not actually on the scene itself, other than perhaps the gun being picked up and dropped in the lap. But the actual position of the body was not suggested to be placed in a way that was staged. Rather, the scene was cleaned and so on, and all those points were made, that in fact that scene pointed towards suicide, but without any scientific basis to support that. So the staging certainly was relied on, but in relation to the note.
Well, you say, don't you, that while it was an issue before the jury, how come, if this was murder, that Mr Edwards, a short time later, ran into the living room and saw his mother-in-law, and he was not covered in blood. So that was before the jury. But you say now Mrs Leake's evidence, plus perhaps the Mastalio Shaw report, is that the likely position of the deceased when the fatal shot was fired was sitting in a chair with her back to the bathroom door, and the bullet is fired from inside the bathroom. And you say, Mrs Leake's evidence is it's pretty well impossible to explain how, if this was murder, the murderer manages to get out and a few minutes later be in the living room with not a trace of blood on him.
Yes. Yes.
I think you said sitting in a chair, didn't you?
On the floor. Yes.
On the floor, yeah.
It's the floor, I think.
Sitting on the
Yes,
floor.
on the
I
floor.
think
Yes.
because the bullet entered the door at about 2'6"
2'8".
above the 2'8" above the
2'8",
floor.
yes.
Yes.
Yes,
Sorry,
yes.
Sitting on the floor with her back against the door.
Yes.
And we have a plan, I think, of the building at 2302.
Yes.
Was that accepted as an accurate plan? Do you know, or
I think it's been done since the trial.
has it?
Yes, we have those instructing me. Mr. Saul Lefrand has produced a plan. That's behind tab 5 in the core bundle. I think it's at page 2302. There might be some slight change on furnishing. I can double check on that, but certainly the plan itself of how the doors open and the rooms and the positioning of the rooms, and the positioning of the dresser and the bed are accurate. They can be seen compared.
Can you explain on that where Mr Edwards, according to him, where he was and then where he went and then?
Yes. So his evidence was he was asleep in bed.
That's on the bed at the top of the plan.
Bed at the top of the plan, and then runs past the bathroom.
Down the hall with the bathroom
Down the
door closed
hallway.
at that point.
Yes. into the living
What's
room.
called passage? Oh,
Yes, passage, yeah.
Yes, through the passage.
And the deceased's mother was
On the couch,
was on the couch.
On the couch in the living room.
And it's all on one level.
Yes.
and the door against which the deceased was propped is the lower of the two doors, the one
Yes.
that is actually the door to the bathroom rather than the door to the
Yes.
passage.
Yes. Yes, which opens outwards. The jury did go on a locus, so they went on a view.
Yes, I do apologise. This is a map. This is a plan produced in 2018.
Yes.
Yes, I'd forgotten.
It was produced by the appellant.
Yes,
And,
it was attached to Mr. Lefroy's statement. Yes.
Yes, that's correct. So his statement can be found at 2,299.
Yes.
If it assists, I can go to some of the photographs if there's any particular questions in due course on the layout. But the bathroom can just about be made out, and the door can be made out on the photographs.
Yes. Thank you.
The impact on the jury, just finishing off that submission in relation to what effect it might have had on the jury. Lundy, of course, sets out that it should generally, if the evidence is both credible and fresh, it should generally be admitted unless the court is satisfied that if admitted it would have no effect on the safety of the conviction. And our submission is that 3 forensic scientists are all converging with conclusions that this is more likely suicide than not, and there being no evidence of a third party within that bathroom at the time of the deceased's death, would likely have had not only an impact but a considerable impact upon the jury. Obviously, the appellant cannot say what the jury would have done if it had heard the evidence, but it is a sensible inference that at least a doubt would have been raised. And the respondent's position now is very much that the forensic evidence was not the central plank of the case, but our submission, looking at the length of the trial and the amount of time spent on the forensic evidence, including the tactic that the counsel took as to the lack of investigation, lack of sanctity of the crime scene itself, as it was considered to be because of a violent death. That focus upon it, but with nothing at the end of it as to what it actually meant, left the jury with only the evidence that the prosecution was able to rely on, which was the lack of GSR. My lords, my ladies, in relation to the constitutional appeal, I can be quite quick on that. And we're looking at the delay, and as well we're looking at the 21-month delay between the appeal hearing in the Court of Appeal in April 2016 and the Court of Appeal delivering judgment in January 2018. And whether the 10-year and the 21-month delay both resulted in a breach of Mr Edwards' constitutional right to a fair hearing within a reasonable time as guaranteed by Section 16(1) of the Constitution of Jamaica. In view of the concession by the respondent that there has been a breach, and also the Court of Appeal, of course, considered that the 10-year delay was unacceptable, and that is at page 1926 in the core bundle of the page number of the Court of Appeal judgment. The issue, therefore, is as set out in the appellant's case. If I can take you to page 2258, which is the start of the submissions, and paragraph 21. We perhaps anticipated, even in drafting the appellant's case, that the remedy was likely to be the area of contention, and that the main issue, therefore, was the trial unfair, or was it unfair to try Mr Edwards? And in light of the concession, I was going to take the board to the case of Cameron, but I'm not going to do that now, but simply refer to the summary of Cameron at page 2260 at the top of the page. And it starts at the bottom of the page, looking at witnesses and attendance of witnesses. Now, as to whether there's been a fair trial, and my lord referred to the reliance upon the absence of Brown, and Cameron is, in our submission, a relevant case in that it's considering very much the context of Jamaica and considering the onus upon the prosecution to get its witnesses there. And our submission is that the Court of Appeal did not fully consider this onus on the prosecution, and the reasoning of the Court of Appeal can be seen. If I can just take you to the Court of Appeal judgment, and it's at page 1926 is where it's behind tab 9. So 1926 is where the Court of Appeal is starting examining the reasons for the delay, and obviously just because it's a delay doesn't necessarily mean that the trial's unfair. And at paragraph 50 at 1927, the Court of Appeal looks at one of the reasons for the delay, and that is where the case had come on for trial some 21 times. So paragraph 50, the case had come on for trial some 21 times before the trial actually started. Although the case was adjourned for varying reasons, this could not be ascribed to willful delay or lack of diligence by the prosecution. The adjournments mostly centred on the absence of witnesses, both for the prosecution as well as the defence, as a result of illness or they being away from the island. This is not a strike against the prosecution. However, our submission is that that is a flawed approach. Firstly, the majority of the adjournments were at the prosecution door, and we set that out in our case, that the prosecution was unable to proceed on 16 occasions when the defence was otherwise ready. And again, I'm going to take this fairly quickly, but the chronology is, there's 3 chronologies in total, but just for page reference, the chronology is at 2154 to 2155. The obligation on the prosecution is not one where it can simply point to its witnesses as being absent and therefore divorce it from its own duty. And in our submission, the Court of Appeal erred in not giving sufficient weight to the prosecution conduct of the case and the effect of that delay. And our submission is it was a strike against the prosecution. If I can just very briefly, in fact, go to Cameron, because it does illustrate the point. It's within the authorities And page 158.
I think you mean paragraph 158. The page is 2519.
I'm very grateful. Tab 6. Very briefly, the delay was around 4 years, which was set out in paragraph 1. And this was delay until the preliminary inquiry. And then moving on to the adjournments at paragraph 159, 2520. The Attorney General accepted the majority of the adjournments have been due to absence of Crown witnesses, which is the situation in this case. Some adjournments were being attributed to the defence. In my view, the Crown has failed to justify or explain satisfactorily the 4-year delay. And towards the end of that paragraph, the Crown also failed to say if and when the preliminary inquiry would be completed. This is symptomatic of the culture of complacency that has taken root in the criminal justice system. This indifferent response by the Crown is a direct progeny of AG's references to the Tapper case. And so paragraph 161 again looks at delay and looking at reasonableness.
The Cameron case, this was a point taken pre-trial, was it? It was an abusive process point.
Yes.
But there was no such application here, I don't think.
There was no abusive process application, and this was there wasn't an abusive process application in Cameron either. Again, it doesn't appear to be procedurally an application that is utilised, particularly within the Jamaican context. At the beginning of the
judgment, it says this is a pre-trial constitutional claim.
Yes. So the complaint was a breach of the constitutional right to trial rather than application of staying the process. For abusive process. And again, we submit that the context is important of the Jamaican system.
Was Mr Cameron in custody?
He was... he was released. He was in custody, and then there was bail applications which were refused repeatedly. And then... So that's set out at paragraphs 4 and 5, at paragraphs 2, 4, 5, 0. So he was in custody. I'll have to double check whether his one bail application was successful before this was considered. I'll double check on that.
I wonder whether it makes a difference. I mean, if somebody was kept in custody for 10 years before a trial, it would be outrageous. But here, it wasn't particularly in your client's interests to have a trial. The prosecution 16 times aren't ready for trial. I know what would happen in the Crown Court here, but if the system is that the defendant's on bail, does it matter?
It matters in a different way to being in custody. Obviously, if somebody is in detention, they will have further rights breached that undoubtedly they will be raising of being held in detention without bail and potential habeas corpus applications in Jamaica. However, a person who's bailed, having been charged with murder and awaiting trial on such a serious offence, in our submission has different challenges than living in society and working and moving on in any way with their lives, so which was the situation here. So it's a different type of seriousness. It's not detention. However, it is a significant restriction upon the person's movement rights to work and to live a life as a civilian. I think we just
when no application has been made or complaint about the delay before the trial, really all one can do is look and see whether the trial was fair or not in the circumstances. You can't really say that they should never have had a trial and it was just inherently unfair when there wasn't any point taken about it at the time.
Yes, we accept we're in difficulties that there was no application, that it was an abusive process to try the case, but in any event, what happened in this case is that the submissions in relation to delay were all made at the close of the prosecution case. So that was the strategy that appears quite normal within the justice system there. So they made the complaints on delay at half time and considered that the prejudice and the unfairness from the delay would be ruled upon at half time and that there would be no case to answer. However, the ruling on the half-time submission was very short. It's a page. And the learned trial judge considered that it depended on the jury's consideration of the witnesses. So her reasoning was about 3 lines. And she didn't engage with any of the issues raised, caused by the delay, and also the unfairness which was raised in relation to the handwriting. Just to complete on the case of Cameron, if I may, paragraphs, just to note, page 2550, this is paragraph 231 onwards, and paragraph 232 refer to this paragraph which says
which page number were you referring to?
I'm sorry, 2550 in the case of Cameron,
Right,
the Supreme Court, Jamaica.
Paragraph
232.
232, thank you.
Thank you. It's necessary to acknowledge the powerful point made by Sykes J that in the US and in Scotland it's long been a part of their jurisprudence that unreasonable delay was a basis for staying proceedings or quashing convictions, regardless of whether the delay affected or would affect the fairness of the trial. And then the court went on to consider the approach of looking at unfairness at paragraph 233 and considers the case of Bell, which is in the authorities, but we don't need to go to it. It appears a significant factor which led to the approach taken by the board was the unfairness of the defendant caused by him having been rearrested for retrial after the prosecution offered no evidence. And it considers unfairness, and at paragraph 255, which is at page 2560, this is when the Supreme Court is looking at how much the delay actually counts against the state, which perhaps explains the language of the Court of Appeal of whether it's a strike against the prosecution or not. And here at paragraph 255, it's looking at the reasonableness, and 256, it's over 4 years since the claimant's been arrested. The preliminary inquiry has not been completed to determine if there should be a trial. Main reasons given as absence of witnesses, and at 259, it's easy to understand why the appropriate remedy where a fair trial cannot be guaranteed must be a stay. Nothing else will be able to vindicate the right to a fair trial. If there cannot be a fair trial, there should be no trial. And just for completeness, at paragraph 263 is where the Supreme Court is also considering the societal interest where there's a serious allegation such as murder. But we rely on paragraph 264 as well, that whilst it's a societal interest to consider where there's a very serious charge, where the accused claims are very serious, the quality of the evidence also needs to be considered. And our submission is that here it was an unreasonable delay, and the quality of the evidence was then further eroded by the absence of Sergeant Brown, and the result being, in our submission, that although there wasn't an application to stay, there still could not be a fair trial, and the application that there could not be a fair trial was made at the close of the prosecution case rather than at the start of the case. But in our submission, at this stage, those complaints still stand good.
In Cameron, they didn't decide then that no trial could take place.
No.
They just said it had been an unreasonable delay.
Yes, that's correct, my lord.
The majority gave the DPP a deadline and said after date X, if you haven't brought the case on, the case will be stayed.
Yes, 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 I'm grateful. Yes, it's a fairly lengthy judgment where, in our submission, it's clear that it was addressing an issue within the jurisdiction. The Supreme Court's addressing an issue within jurisdiction of an attitude of delay, which is, in our submission, very pertinent here. If anything, with this case, it's gone back to that type of prosecution that was very much deprecated. It was that type of prosecution that was very much deprecated by the Supreme Court of Jamaica in 2018. And this case is a
back. It was part of what they were deprecating, presumably,
yes.
in 2018.
Yes. The other aspects that we rely on in relation to delay are set out in our case, and considering the lack of the exhibits and so on, and it's accepted that the exhibits obviously were destroyed in 2009, and undoubtedly if the delay had been less than 10 years, we would be making the submission on effect on fair trial because of the loss of the exhibits. So the time itself is not, in our submission, one that necessarily is conclusive, which is obviously what the authorities say. But the effect is, since 2009, all of the exhibits that are of any relevance to the case have been destroyed. The importance of Sergeant Brown's evidence we've set out in our case, and I don't propose to repeat that. We also, in our case, rely on the absence of the pathologist, Dr. Sesaya, who was the original pathologist who examined the deceased and had emigrated to India, and the prosecution took the view that it was too expensive to bring him back to Jamaica. And so another pathologist stepped in, and there was some complaint from the counsel representing the appellant that they were hampered in how far they could go in examining the different scenarios of suicide and murder because of the lack of that original pathologist, because the stand-in pathologist was referring to notes which he had not written. And so it appears from the record that ultimately a decision was taken not to refer to the handwritten report of Dr. Sejaya because it was too difficult for the stand-in pathologist to interpret the handwriting or the thought process and the thinking of that pathologist. We don't have further detail than what is set out in our submissions, but our submission, it's an added factor that the pathology is central to any homicide case, and the pathologist was available, but a decision was taken by the prosecution, effectively too expensive to bring over.
What precisely would the pathologist have been bringing to the debate? I mean, you could comment on presumably the proximity of the gun to the skull at the point of the gun being discharged. You could obviously point at the angle of the bullet passing through the deceased's head, but what seems to be much more critical in this case is the layout of the room where the bullet was in the door, things like that, rather than anything that a pathologist would bring. I'm struggling at the moment to see what the pathologist would add to the picture.
Yes, my Lord, it would be very usual with a pathologist who's carried out the examination to put a particular scenario to a pathologist, and
yes,
that wasn't done in this case. So a scenario of suicide would normally be expected to be put to a pathologist of the position of the body, looking at the position, the angle of the bullet, which is very much within pathology, and for then to be a comment on that scenario. This was a case where counsel did not approach that, putting a scenario, because they were concerned that the original pathologist was not there, and the notes.
So it would be a combination of the pathologist's examination of the body and putting the photographs to the pathologist, yes, for his commentary.
Yes, and then putting...
it seems to me a key point that the pathologist made was that there was no other injury to the body or no other sign of the deceased having been subdued or having been punched unconscious and then propped against the door. So, but was that accepted by the Crown, that there was no evidence that the deceased had been sort of manhandled into the position in which she was in, or had been stunned or something and placed there before she was shot?
Yes. It was accepted that there was no evidence of struggle, injury, additional injury to the deceased above and beyond the gunshot to the right side of her head. However, it does, in our submission, lead to one of our other grounds, which relates to the summing up, because there was a lack of reference in the summing up to the points made by the defence, which included lack of struggle, lack of other injuries, lack of explanation as to how the person could have been there in that position, and so on. And so the pathology potentially left a gap of a scenario which was put in submissions, was not able to be adduced on an evidential basis through a pathologist.
But is that significant, really? I mean, perhaps I shouldn't give evidence, but certainly, even in my experience of homicide trials, if the pathologist's evidence is not crucial, contentious, it's very common to be told Dr. So-and-so is unavailable, but the prosecution can field a substitute, and the points such as, well, there was no evidence of struggle, was the doctor? Surely we would have found that can be put to the substitute.
Yes, my Lord, I completely agree within this jurisdiction, and what I would pray in aid of our submissions is how the trial is conducted within Jamaica, in that you will see from the record that objections are made to evidence, admissibility of evidence, literally as it's about to be given by the witness, that there's not the same aspect of agreement between prosecution and defence as to what may or may not be adduced. and therefore there's not the same situation of agreed facts, for example, and restriction of witnesses, and therefore the defence appear to be slightly cautious that they don't want to ask a question that they don't know what the answer to, because there's no agreement in advance, and that is the difficulty when you have a substitute pathologist in our submission in a jurisdiction such as Jamaica, as opposed to here, where there'll be agreement as to what a pathologist can refer to, communication if there's any misunderstanding of notes, and so on and so forth. But here, the notes were considered simply not to be relied upon because there'd been no communication, it appears, between the two pathologists as to what the notes meant. And so potentially the defence lost some aspect there, but I can't take it any further because we haven't obviously.
But, sorry, are you saying that you had that the appellant's team at the trial didn't know in advance of the stand-in pathologist going into the witness box whether he would support and repeat what Dr. Sashaya had said, or whether he was going to come out with some different view?
It was perhaps more subtle that Dr. Josiah was not, on the face of it, giving evidence as to whether it was suicide or murder. So that the subtlety being that if Dr. Josiah had given evidence, he would have been able to potentially been referred back to his notes and a scenario put to him. In his absence, with a pathologist who had not had communication with Dr. Josiah and did not know what was in his notes, that therefore appeared to be and felt not to be a position that the defence could take. It really, in our submission, goes to a lack of forensic evidence, such as the fresh evidence that we are seeking to admit. They didn't have that platform on which to put any evidence to the pathologist. And they didn't know that the pathologist, as far as I understand it, I can double check, but they didn't know that the pathologist was not available, Dr. Josiah, literally until the trial. And
so have you got a date for when he became unavailable?
We do. There's immigration.
I mean, I don't want to labour this because I don't think it's your strongest point, if I might put it that way. But,
yes.
You know, you're trying to establish this as rendering the trial in some sense unfair because of the delay.
Yes.
But without the dates, this could have happened the day afterwards.
He was unavailable. The immigration evidence was called as to his unavailability, and he certainly, I can give you the date shortly.
It's mentioned in the summing up, I think.
Yes.
The judge goes through the immigration evidence before looking at the evidence of Mr. Phipps and Mr. Major.
He left Jamaica on the 8th of August 2009.
Thank you.
I'm very grateful. But the defence didn't know that until the trial, as far as I understand it. In relation to this, as relying on this as making the trial unfair, our submission is it's combined with absence of Sergeant Brown, destruction of exhibits as set out. So it's one factor amongst others, and as a standalone, we can't take the submissions any further than we have done.
No, thank you.
To address the on the investigative point, on the forensic evidence, just one further point which we set out in our written statement is the respondent considered that it was speculative, the lack of a secured scene and what might have been adduced from that scene is speculative. And there's no unfairness that could be demonstrated by the destruction of the scene. However, we do rely on the evidence from the prosecution witnesses themselves, and particularly Superintendent Hibbert, Superintendent Hibbert Mitchell, and it's within the record at page 223. I'm just going to refer to what he said, where he said he very much agreed it would be inappropriate for blood spattering to be removed from an area before the scenes of crime persons come. And he set out, and the page numbers are within our case, he sets out the issues with the clearing of the crime scene. And we continue to rely on those. It's not speculative in our submission. There is a reason why scenes of violence are preserved. And the
what
reason...
are you saying
yes.
would have happened in this case if it had been preserved that didn't? Well, I thought we were told there was nobody in Jamaica who could give evidence about blood splattering anyway.
It would have enabled... It would have enabled some examination to be carried out, such as GSR examination in the bathroom, if there was no GSR, as there was no GSR at all found, if there was no GSR found at all in the bathroom, that again might have added a further red flag as to the reliability of the methods that were being used. And the blood itself and the spattering of the blood itself, it might have been evidence that could have been utilised with a pathologist. It's the sort of evidence that can be utilised with a pathologist. However, in this case, it becomes rather circular because in this case, the pathologist was not present who would have been asked to answer questions around blood spattering.
But there's the point you made earlier about the absence of any smeared blood on the door, showing that it was very unlikely that the body had fallen over and then been propped up again.
Yes, so there was that evidence was photographed. So there was a photograph of the smear on the door, and hence that could be pointed to. However, the photographs were not of particularly good quality. There may well have been other aspects, such as pointing to blood within the bathroom with no footprints within it. But all of that was cleaned before it could be examined. It might sound speculative. However, there's always an evidential basis whenever there is an investigation of a scene which has got a large amount of blood in it. And one of those investigations would have been as to the likelihood of another person being there before the blood started to flow and was able to exit in that way. And so it was very limited as to what could be done, and therefore prejudicial and unfair, and unable to be remedied to a large extent, save for the fresh evidence, which really links to our looking at the 6 grounds that we set out in our written statement, having moved from the constitutional grounds. At paragraph 46, we've got our 6 grounds that we were granted leave or granted permission to appeal upon. And the fresh evidence and the lurking doubt we have been addressing. The lurking doubt, if I may put it in this way, I'm sure your lordships are very familiar and your ladyship's very familiar with lurking doubt being deployed in a way that was done in the case of Pope. Perhaps if I just take you to Pope very quickly. It's in the authorities bundle behind tab 18.
Which page?
It's page 2754.
Thank you.
And this case is a Court of Appeal case which considered a trial by jury and where there might be, there's no complaint on a case to answer or directions to a jury, but where there might be a sort of judicial hunch. And Lord Judge, looking at page 2757, this was a case at paragraph 12, and it is this case I'm referring to is relied upon by the respondent, but here there was no criticism made of any ruling made by the trial judge or any aspect of the conduct of the trial, which is agreed all round was flawless. So that's not the case here. And then there was a submission made of a lurking doubt at paragraph 13 and 14. And then there was a consideration at paragraph 14 of what a lurking doubt might be. And about halfway down that paragraph, where this case has been found to answer after proper directions, the jury is convicted. It's not open to the court to set aside verdict on the basis of some collective subjective judicial hunch that the conviction is or may be unsafe. Where it arises for consideration at all, the application of lurking doubt requires a reasoned analysis of the evidence or the trial process or both, which leads to the inexorable conclusion that the conviction is unsafe. In our submission, this isn't a classic lurking doubt Pope type case because there are so many flaws throughout this trial of this appellant, and we refer to it perhaps more within a context of considering lurking doubt in the Ducan context. And if I can just take my lords, my lady, to that case, the case of Ducan, and it's at page 2571. And here, paragraph 1, judgment from Lord Roger. Paragraph 1 deals with the appellants who were convicted of murder of Chandar Day, and this was background to it. Paragraph 2, there was some motive of jealousy between the two women, and the case evidence rested on eyewitness evidence, identification evidence, plus which was contested, which is set out at paragraph 3. And the facts don't really set out any new proposition, but the proposition really starts at paragraph 28 at page 2578, where set out, nor did the board accept that if the conviction of one of three accused is otherwise safe, it can or should be quashed on the ground that convicted only one of the accused is unfair. And then about halfway down that paragraph, where there's a renewed submission that in all the circumstances there's a lurking doubt about the safety of Malhari's conviction, although reference to lurking doubt has been criticised from time to time as an unwarranted gloss on the language of the statute regulating appeal proceedings in England and Wales. It's really just one way in which an appeal court addresses the fundamental question, is the conviction safe?
vast majority of cases, the answer to that question will be found simply by considering whether the rules of procedure and the rules of law, including rules on admissibility of evidence, have been applied properly. Exceptionally, however, even where properly applied on the basis of general feel of the case, the court experiences it, there may remain a lurking doubt. Our submission is that this case is not so weak as to place all its arguments on lurking doubt. Rather, it is placing the arguments on lack of safety, and the lurking doubt really is to express overall how the board...
It's a sort of last resort submission, but your case is a bit stronger beyond that, doesn't it?
Yes. Yes.
You're saying that there's a positive reason to conclude that he's been wrongly convicted here.
Yes, absolutely, my lord. It's really because we obviously it's part of ground one, and because of the reliance of the respondent on Pope, it was really to clarify where we are on that. We're relying on the Dukran unsafe, and certainly not submitting that procedural and admissibility rules were followed. As to the...
Sorry,
yes.
No, before you go on, Pope and Dukran and the obvious divergence of view between Privy Council in Dukran and Lord Judge in Pope, that's concerned with cases where there is no fresh evidence and the Court of Appeal Criminal Division or the local Court of Appeal or this board are being asked to say, on the material before the jury, we just don't think it stacks up. But once fresh evidence is admitted, if it is, then we're into the Stafford, Pendleton, Dial,
yes,
that line of authority, where it's very different, isn't it?
Yes. Respectfully, we'd agree with that summary. We probably don't need lurking doubt in there at all. But it's been those cases are referred to. They're still in our submission relevant in looking at safety and Dukran. As much help that the board gets from Dukran, that's where we place our reliance.
In your case, you refer to Stafford as a lurking doubt case, but I don't think it is it? I haven't read it all, but I'm not. They're just saying that the fresh evidence might have led to a different result, and therefore the verdict is unsafe.
Yes, yes. My lord, I can deal with that aspect of the appellant's case fairly swiftly. There was, because of the seriousness of the conviction, there was an element of ensuring that every aspect perhaps was added. And so lurking doubt was included as an aspect to be considered if thought so. But because of the strength in our submission of the fresh evidence itself very much overtakes any consideration of lurking doubt. And moving therefore to the submissions at paragraph 58 of the case, this is where there's a summary of matters that were relied upon by the defence at trial but didn't actually feature in the summing up. And they're set out there, which include that there was no evidence of struggle and so on. So these were the points that I made submissions upon earlier, and they're set out. There's a number of them, but it's very much the defence case, which in our submission, the summing up, although lengthy, in essence, in our submission, it reiterated evidence that had been put in front of the jury, but didn't assist the jury.
And a lot of it's a narrative of the witness's evidence, but only the occasional piece of analysis.
Absolutely. It is a narrative, and because the narrative was that the prosecution evidence sequentially came first, the majority of that narrative landed on the prosecution evidence, which caused an unbalance in that the defence called the defendant and Mr Hayward, the handwriting expert. But that really only featured towards the later part of the summing up. If I can just give some examples, I'll just give an example as we made submission in relation to the witness Brown. And my lords, if you could turn to the summing up, it starts at page 1446.
Sorry, say that number again.
I'm sorry, 1446. And one example of how the pointing out the note was dealt with starts at page 1615. And this is where the learned trial judge is summing up the evidence in relation to what was at the scene and Mr Phipps's evidence, D.I. Phipps, and it's against little 6, where she sums up, he said his attention was drawn by Woman Sergeant Brown to an open book on the dresser in an adjoining bedroom, and this was done in the presence of Mr Edwards. And you recall in cross-examination what took place as it related to that statement that he made, but we will get there. He said that Woman Sergeant Brown told him in the presence of Mr Edwards that Mr Edwards had drawn her attention to the book, which had certain notes in it, and then he went on to tell us what was contained in the note. However, the notes in Evidence Exhibit 5, you'll have an opportunity to look at it, re-examine that those words. He said he had called the scenes of crime unit, and on their arrival at the premises, he gave them certain instructions. So that's the first reference with a slight, you might recall something in cross-examination. It's then picked up again at page 1618. And just under a few lines down where we've got the time of 10:30 a.m. He said that the open book in the photograph had been shown to him in the presence of the accused by Woman Sergeant Brown. He said the book contained certain words written in it, and he took possession of the book on the same date, the 5th of September. He described the book. He said he took possession of the book after the photographs were taken. He said the scene was allowed to remain. So again, there we have summing up to jury, not even with a reference to this was disputed. And then it can be picked up again at 1620, where the trial judge again refers to the notebook. It's a Sikh notebook, it's the top of the page. This Sikh notebook, which was opened on top of the dresser and which he said was pointed out to him in the presence of the accused by Woman Sergeant Brown. Again, put to the jury as if it's not...
Well, that's a different point.
Yeah,
that's not a point about Sergeant Brown saying that it was Edwards who had drawn her attention to it. It's simply saying that Brown is drawing...
That Edwards was present when she pointed out the book, which is neither here nor there, really.
No.
Well, other than it was disputed that the evidence from Mr Edwards was that he didn't know anything about the suicide note until it was shown him at the police station the following day on the 6th of September.
Yes, so it's in the presence of the accused is the point.
Yes.
I see.
From there.
So it was part of the narrative from Mr Phipps that in the presence of Mr Edwards, Miss Brown said that he had pointed out the note to her. But it was very much disputed.
Sorry, let's not mix up the 2 points. There's
Yes.
a point about whether Brown told Phipps that she had originally been shown the note
Yes.
by Edwards, but then there's this point, which is that Edwards there when Sergeant Brown showed the book, at least, the Sikh notebook, at least, to
Yes.
Phipps. But you
Yes.
say that that's significant because Edwards denied that he was there when this happened at all.
Yes, and the jury would have understood the two slight subcategories as being the same, because when she first refers in her summing up at page 1615, she puts it in a fuller way. So that's at opposite paragraph 11. He said that Woman Sergeant Brown told him in the presence of Edward that he had drawn her attention to the book. So
What page is that?
Page 1615. So that's when she first, opposite little 10. 8 to 10, 1615. It's all part of the same interaction, supposedly in the presence of Mr. Edwards.
Where is the summing up? Perhaps you're just getting to that, in which dealt with
the
question
defence
of whether Sergeant Brown had said that it was Mr. Edwards who had pointed out the notebook to her in the first place.
In the summing up, she says it there that Mr. Edwards.
I don't think she does come back to that. Well, I mean, she may have somewhere in this
Yes.
hundreds of pages, but I don't think so.
Yeah, so she says it there at 1615. She then, you're quite right, she then refers to another 2 times that the book's pointed out by Brown in the presence of the accused, which we submit relates back to the same point that he's making, that's when the interaction took place, the conversation. He's told me this is there. And then at page 1636.
Yes, at the bottom of that page, there's the reference both to Sergeant Brown drawing attention to the book and Edwards and stating that Edwards pointed it out to her.
Yes.
1636.
So this is the fourth time it's been referred to without the defence dispute put alongside it in any way. And then the dispute...
The note was actually written on a page of the book, was it?
It was a note in the book.
But was it on a separate piece of paper placed in the book? Or
Separate piece of paper at the front of the book. And the book had got the name of the deceased on it, which Mr. Major considered to be the same handwriting as the other names on the other 2 books.
Sorry, so it's a loose piece of paper slipped into a notebook, or a sheet of the notebook?
A sheet. Just bear with me. It's a sheet at the front. Can we get back to you on that?
Well, there are various well, I suppose the photocopies of it wouldn't show necessarily whether it was a loose sheet or whether it was a sheet of the book.
Yes. I have to say, having gone through the entire questioning of Mr. Major, it was hugely confusing. So I can't take you to a section, but we just want to make sure we get it right. And we'll get back to you on that. But the page, so 1636 is when she comes on to, turning over the page to 1637. It's when the learned judge comes on to the defence. So it starts at the bottom of 1636, that it was disputed.
Well, then the judge does point it out.
She does, yes. She does point it out, but our submission is as an example of how the summing up is done. She refers to it without any controversy until this stage. So this is the 5th time she's referring to the note being pointed out in the presence of the accused, and only at this stage does she say that.
It really doesn't get you very far, does it? I mean, the thing is, this is a pretty useless notebook summing up, but if that were to be a ground of appeal, then we'd be, not many convictions would stand up in the Court of Appeal, unfortunately.
Yes, it's one factor. It's one factor looking at the summing up. And we refer to that style of summing up in support of the submission that it was unbalanced towards the prosecution, with the prosecution case being repeated as a narrative, and then the defence case or where the defence case challenged the prosecution case, it came in a very small section. But the narrative already in our submission had been embedded in the jury's mind.
It was slightly odd because at 1637, the learned judge presented the matter to the jury as a question of credibility. Was it a genuine omission from his statement, or had he invented it, rather than saying, well, after the passage of time, is his evidence on this reliable, having regard to the fact that it wasn't in his statement and wasn't in Sergeant Brown's statement?
Yes. Yes.
It was setting up a binary question which is perhaps not the main focus of what it should have been.
Yes, absolutely. We respectfully agree with that a bar was set very high. Is this an untruthful officer? And in fact, that officer also had support from some of the other officers who referred to how honest and decent he was. And he was a superintendent, very high ranking.
Well, she starts that page. You've asked her, this is a senior police officer. And he's saying, yes.
Yes, which has some impact. The level, this isn't a junior patrol officer.
But was this point put, did Mr Edwards give evidence about this point, and was that summarised by the
summary on Mr Edwards? This was the point on the cross-examination. I'll come back to how Mr Edwards's evidence was summarised, but there wasn't much reliance, there wasn't much emphasis put on it. It was similarly, in our submission, a similar pattern can be found in the summing up in relation to the GSR and the number of times that the GSR is the gunshot residue, lack of it on the back of the hand, is referred to. And I'll come on to back to the appellant's case in relation to that, to refer to the page numbers. But just on this point, first of all, and really to perhaps conclude where I should have perhaps concluded on the respondent's response to the submissions that have been made by the appellants so far, is that this is an appellant that is really relying on holes in a prosecution case. And perhaps as my Lord has observed, there's always going to be some holes and complaints in a prosecution case. And the Court of Appeal relied on the case of Abraham, and also the respondent looks at the case of Abraham, and also the case of RD. If I can just deal with those very briefly, because our submission is that this case and this appeal is in a very different category to picking out holes in a prosecution case, whether that be in summing up or lack of exhibits or treatment of the defendant. And Abraham is in the authorities. It's at tab 13 and it starts at page 2694.
And this case, there was 2 cases, and the head note sets out the first case. This was where the applicant was charged with common assault, allegedly committed in a Tesco's superstore, and there was a videotape recording of the CCTV, which had been destroyed before he had his trial. And the magistrate refused the application that he could not have a fair trial, that the case be stayed because of destruction of that CCTV recording. So that's set out under little c. Under D, the second case was where it was a speeding case, and the videotape recording made by the officers of the speed, which the defence said was essential, had been destroyed, and it was the same submission. And Lord Justice Brooke considered both cases and considered in our submission what's relevant here. He considered the duty on investigating authorities, and he looked at, as applies here, the Code of Practice and the Attorney General's guidelines as they then were. Back relevance was 1997, so that's paragraph 8 at page 2698. And he's looking at the material that may be relevant to the investigation. And at paragraph 9 at C, and this still remains within the code, within PACE, in conducting an investigation, the investigator should pursue all reasonable lines of inquiry, whether these point towards or away from the suspect. What is reasonable in each case will depend on the particular circumstances. And the submission here, in relation to Mr Edwards, is that the investigation did not carry out reasonable inquiries, including those that pointed away from him and pointed towards him being not guilty or innocent. And therefore, the complaints that are made that form the basis of this appeal are at the core of the safety of the conviction and at the core of the prosecution of the case. They are not holes or complaints about style in terms of summing up, but it's really taking it all together with the fresh evidence. And in Abraham, at paragraph 16, this is looking again at the duty at H, towards the bottom of that paragraph. It cannot be said that they are abusing the process of the court merely because the material is no longer available. If, on the other hand, they were in breach of the duty, then the court will have to go on to consider whether it should take the exceptional course of staying the proceedings for abuse of process on that ground. And over the page 2701, at paragraph 19, paragraphs 18 and 19 is where Lord Justice Brooks sets out the 2 categories of cases which will be familiar. The first one looking at a category of case which has some form of bad faith manipulation, and another one where the trial would be unfair, it would be unfair for the defendant to be tried. That's paragraphs 18 and 19. And here, although it's not submitted that this is a bad faith destruction of exhibits or lack of investigation, however, we do submit, looking at paragraph 19, that the prosecution here has been guilty of such serious, it's set out here as misbehaviour, but we submit that that misbehaviour does encompass where the conduct is so serious in that there's just been a lack of a fundamental investigation which caused the entire trial to be unfair. And if we receive support in that submission from paragraph 23, where One of the unreported cases was considered, paragraph 23, and it was considered there whether there'd been either an element of bad faith or at the very least some serious fault on the part of the police or the prosecution. So we submit this is serious fault. It doesn't have to be misbehaviour in terms of bad faith, but there's a serious fault here in the destruction of the exhibits, the absence of testing the holster for fingerprints and DNA, the absence of testing the gun for fingerprints and DNA, the absence even of securing it. The gun itself was not even packaged properly. It was received as an unpackaged exhibit. And in a case such as this, where as early as at the scene, the appellant was saying to the police that the deceased had shot herself, and then on the 23rd of October, he answered questions in interview, setting out what had happened, that she had killed herself. In a case such as this, in our submission, it's a basic duty of investigation as to whether her fingerprints were on the holster, whether her fingerprints were on the gun, or whether her DNA was on the gun and on the holster. And that gap in our submission is one which is very different to side evidence, in effect, that might have been destroyed, such as Abraham considers, and such as the following case, which was Mr Justice Tracy, which is at page 2765. This is a 2013 case. I don't propose to go into it in any detail, save to distinguish it in that this was particularly at a time where there was applications to stay prosecutions of sexual offences, historic sexual offence complaints. And this arose, a number of those cases were being stayed because the time that had passed between complaint, between allegation of offence and complaint. And this case considered what the complaints were, dead witnesses, buildings being destroyed, and so on and so forth. However, at the core was the evidence from the two complainants who were capable of giving their evidence of the complaint. And in conclusion, in the Court of Appeal, they considered that none of those matters that were complained of would have had such an impact, in that there was ample opportunity for the offences to be carried out by the appellant. And so they were effectively holes in the case, side issues, but not ones which went to the heart of the prosecution and the fairness of the prosecution. And in our submission, that those cases are very different to...
Well, in this case, the initial failure, you say, was the cleaning of the room immediately after or very shortly after the event, before the scenes of crime officer came on the scene.
Yes.
And that presumably was because the police had a prima facie view that it was suicide.
Yes. I
think there was evidence that they didn't initially consider it to be homicide.
Yes, that there was some evidence from Mr Phipps that he didn't consider Mr Edwards to be a suspect at that initial stage. The bathroom was cleaned around 3 p.m.
Yes.
And the first officer there was at 11:56 a.m. That was Sergeant Brown.
Yes.
So that was the time. But the scenes of crime officer actually only attended the following day.
So you're really founding more for fundamental lack of investigation. You're founding more on the circumstance when the police began to suspect that Mr Edwards might have been involved, and you're found leading up to the interview on the 23rd of October, and you're founding on things like the holster, the gun, and so on.
Yes.
Rather than the initial mistaken decision to clean the room, albeit that obviously gave rise to considerable loss of evidence.
Forgive me. Although we rely on we also rely on that decision-making as not having any logical thread within it. This is a violent death, and at that stage,
Yes,
none of, even within the Jamaican context with its own procedures, there was no guidance that a scene would not be secured. So, because that's the start of the investigation.
Was the instruction to clean the bathroom given after Mr Phipps and Sergeant Brown had seen the suicide note in the book?
Yes, because the instruction was around 3 p.m.-ish, and the evidence appears to be, although Kellyanne Johnson had some difficulty remembering, that she'd actually gone to hospital with Mrs Harris, who'd fainted and then returned. And so there was some 3 hours of it's a fairly small house, so it was some 3 hours. So it seems that the book would have been found by then. Yes. My Lords, the submissions made have really probably morphed slightly into ground 2 on the wholesale investigation failures, and we also set those out. I think we've probably been over all the failures, but they are also within the appellant's case. And if we can move now to ground 3, which is the failure to exclude or adequately direct on the handwriting evidence. If I can just bear with me one moment. Yes. So within our written case, we set out the facts with the references to the summing up, in particular, and the record starting at page 2280. And in headline summary, the submission is that the evidence of Mr. Major, who conducted the examination of the specimen handwriting and compared it to the suicide note, that it was fundamentally flawed because it relied upon a methodology that was fundamentally flawed. And that methodology was that Mr. Edwards was directed to copy out the words on the suicide note. So with the note in front of him, he was directed to write the same words. And although it might not have been a specific direction all the way through of copy, as in make it look the same, there was no dispute by Mr. Major that the leading authority on obtaining handwriting assessments should start not with a procedure where the handwriter is copying. And paragraph 90 of the written case really sets out our arguments here and the various page references. And it's at 90 little 1 and little 2. And the page references are from the record and also from the summing up. I should warn the board that the examination, cross-examination of Mr. Major is incredibly long and probably would have been hugely confusing for the jury.
Did he produce any report that was disclosed to the defence in advance?
He produced charts in court which were, so he enlarged the handwriting after he'd made his conclusion that it was the handwriting of Mr. Edwards. And as for report or statement, He relied on a statement that he produced, now whether that was in a report, but there was no particular workings. It went to...
I was just wondering if we have a document where we can see summarised his analysis, such as it was.
I don't think...
I mean, you might expect, I mean, you would in this country expect...
Yes, we don't. What happened was the summary of his analysis was he produced charts before the jury where he, in particular, focused on a Y, and then he moved across in the chart of a similarity with a Y. And then there was cross-examination on that Y appearing in other books in a similar way, but we don't have those charts. I don't know what's happened to them.
And there's no document in which he summarised his
no
views.
And that was one of the complaints at the time, that it went to finding rather than consideration of findings, and also that he did not analyse the other books that were recovered, which were presumed to be the books of the deceased, where she'd written within them. So he didn't look at the handwriting within those books in order to see whether there was variance as to how she wrote. Because I think both experts accepted that people aren't robots. They will vary to some degree when they are writing. And so he focused purely on looking at the note and comparing it to the specimen by Mr.
But I thought he also said it wasn't her writing, or not?
He said he thought it was the same writing across the three books.
Right.
However, at one point he appeared reluctant to pin himself down on that one.
But so he didn't give an opinion on whether it was not her writing, only on whether it was similar to that of Mr Edwards. Is that right?
Yes.
I mean, we do have
Well, he gave an opinion. Yes.
Well,
he compared. Sorry, my lady, I interrupted.
No. Finish what?
Yes. He gave an opinion on the. So he focused on the comparison between the suicide note and Mr Edwards' writing. When he was cross-examined on comparing the suicide note to the other two books with the handwriting in, he wasn't conclusive whether it was the same person.
I see. So he didn't, as part of his evidence in chief, give any comparison and opinion about whether the writing in the note matched the writing in other examples of her handwriting.
That's correct. He did not.
He did not.
He did not. He did focus. There was quite a lot of cross-examination focusing on the name that was written inside the three books, and whether that name was written by the same person. And again, he was slightly equivocal at different points, but settled on it being the same person who'd written the name in the three books.
But was the writing of the name in the three books, and there was some sort of dancing about as to whether that was her handwriting?
Yes.
So there was no other specimen handwriting of the deceased that was given to Mr Major as a comparison? Or, I mean, we do have a written report of Mr Hayward.
Yes.
There doesn't seem to be...
And he, yes, absolutely. And he criticised as well. He makes the comment that the majority of the writing in the other books did not appear to have been analysed by Mr Major. So that was one of his points.
Right. But how much writing was there in the other books, which one can assume was her writing?
There was a lot of writing in one book, which appeared to be more of a... perhaps a book for study. There was writing and numbers within it, but certainly one book there was a substantial amount of writing in it.
But there wasn't any evidence from, or was there any evidence from either of the handwriting experts comparing that writing with the note?
Not in relation to Mr Major, and it probably and Mr. The comparison with Mr Hayward focused on the methodology of Mr Major and focused on the lack of a suitable specimen to make the comparison. And so his conclusion, which we summarise at paragraph 93 of our stated case, was that Mr Edwards could not be confirmed as the writer of the suicide note, but he could not be excluded either. But the gravamen of Mr Hayward's evidence was because the specimen was insufficient to reach a conclusion effectively one way or the other.
But Mr. At page 2222, Mr Hayward does seem to compare her handwriting with the question document, as it's called. Too limited.
But he's saying it's too limited and it's not sufficiently comparable in wording and letter combinations.
Yes.
Positive conclusion.
Yes, the record was 1,171 to 1,172, where he found the sample to be inconclusive, where he found that his conclusion was inconclusive due to, inter alia, the limitations posed by the requested samples. So that's where he ended up.
But you're telling us that Mr Major only looked at one side of the picture, and in a situation where there were only two candidates, he only looked at one candidate.
Yes.
But isn't the implication of his identification, this is the writing, effectively saying, this is the writing of Mr Edwards, the implication is it's not the writing of the deceased. So to that extent, he has ruled out that it was written by her.
Well,
Sorry,
well, he has by implication.
He has by implication.
Her writing may or may
out.
not be similar. I mean,
yes, I think I probably confused myself on that one. The handwriting sample, perhaps I deal with it in this way, looking at paragraph 90 and his conclusions. So I'm not short-circuiting it. He concluded that the specimen handwriting from Mr Edwards and the suicide note were written by the same person, and that the names variously written in the Sikh notebook, the Mead notebook, and the John Dickinson notebook, namely Aldonna Harris or Aldonna Vasquez, were written by someone else. And then he was cross-examined, and he said that he did not request any standard writing for the deceased, which would be the writing in the other notebook. So he didn't request any standard writing. And he accepted that if somebody had been asked to copy a specimen, that would impact on their handwriting sample. And this is the core of the submission here. That although it might not be copying, in that he was asked, try your best to duplicate what's on the note, he had it in front of him and he was asked to write it out, which it should not have been done in that way. It should have been dictated if it was to be done using those words. And Mr Major agreed with the leading authority that handwriting assessment should start not with an examination of the question writing itself, which, my lord, might be, I think was probably your point, i.e. the note, but with a careful study of the standard writing with which it is finally to be compared, i.e. Mr Edwards' natural or ordinary handwriting, and the genuine writing should, if possible, be made before the question writing is seen by the examiner. And Mr Major stated the specimens should be untainted, namely that the disputed writing should not be given to the person providing the specimen before they provide their specimen. So he accepted that in evidence.
But wouldn't that rather be the worry that the person giving the specimen will try and make their handwriting very different from the note.
Yes, absolutely. Or perhaps subconsciously the person could be influenced. Because here, actually pictorially, the writing, I think Mr Hayward agreed that pictorially the handwriting looked quite similar. So it's not where there's a definite attempt to change the handwriting, but undoubtedly that's one of the reasons that it shouldn't be tainted.
Do we have the photocopies?
We do.
I wonder if that's something we can return to.
Yes, I can return to it.
Court adjournment.
Yes, we have. Oh, I see the time. I can return to that and then complete on submissions on the handwriting if that's a convenient moment.
Thank you. Court will adjourn.